Coming up, and notwithstanding the claims in the article that the reinterpretation is being proposed out of a desire to promote the common good, I would argue it's something quite different. I would argue it's motivated by frustration that the population hasn't bought into what this Harvard law professor, and I suspect many of his brethren, view as the common good. This isn't the first time, and it won't be the last time, that a representative of one of our most elite institutions advanced a proposal that would make anyone, should make anyone who values their rights, wonder what exactly makes this institution elite. Welcome back to Political Spirits. I'm your host, Franklin Rye. We still stand for the proposition that the left and the right should have a few drinks and talk. Compromise is not a requirement. If those discussions result in us changing or even abandoning our positions, that's fine. If they don't, that's fine too. We just need to talk to each other. In that way, we can unify through speech. And if the discussion becomes a bit heated, at the end of the night, we should still be able to split up the bar tab and be on our way. So what are we going to talk about this week? Well, this past week, we witnessed some of the best legal and political news we've seen in a long time. And at the top of that list was the decision of the Department of Justice to drop the charges against retired General Michael Flynn. I've watched with dismay for the last 3 years prosecutions and investigations which seemed obvious to me to be politically motivated, prosecutions which it seemed obvious to me would never have been started if Donald Trump was not president, prosecutions which were designed and intended more to weaken the president, target the president, and prevent him from accomplishing his goals, much of which include unwinding the changes put in place by his predecessor, Barack Obama, than to actually punish persons guilty of crimes. Get a load of the question that FBI agent Bill Priestap asked in the government transcripts which were finally released prior to the DOJ moving to dismiss the charges against General Flynn. Referring to the FBI interview of Flynn that was about to be conducted, Priestap asked, quote, "What's our goal? Truth/admission, or to get him to lie so we can prosecute him or get him fired?" Close quote. Got that? The FBI was engaging in discussions about getting a senior White House official fired. That was at least raised as possibly the goal. I thought they were a law enforcement agency. I thought the president gets to appoint the senior members of his team. I never thought that the FBI effectively had a veto power. But you say, of course they should have that power if they uncover criminal conduct by a senior government official on the president's team. They would and should advise the president, and the president may very well then fire him. And regardless of that firing, the FBI should turn over the information to the Department of Justice so that it can decide whether to prosecute. But that isn't quite what happened here. The investigation into General Flynn, codenamed Crossfire Razor, found nothing adverse to the general, and the FBI recommendation was to close it down. Through bureaucratic inefficiency, the closure of the investigation had not formally occurred, notwithstanding the preparation of the memo required to close it. Upon discovering that the bureaucrats within the agency hadn't actually completed the formal closing of the investigation, notwithstanding the fact that it was supposed to have been closed, one FBI agent was ecstatic. Peter Strzok. You remember him? He's the FBI Deputy Assistant Director who ended up on the Robert Mueller team and was thrown off of it when a massive set of texts, over 7,000 texts, made on FBI-issued cell phones between him and his fellow FBI agent lover, Lisa Page, were made public. His statements in particular evidenced an overwhelming animosity towards President Trump. You remember those texts, don't you? They include Strzok assuring Lisa Page that Trump wouldn't become president because, quote, "we'll stop it," close quote. And then there's his even more revealing, quote, "just went to a Southern Virginia Walmart. I could smell the Trump support," close quote. And by the way, smell is in all caps. Ask yourself what the odds are that General Flynn, chosen by President Trump to be the National Security Director in his administration, would get a fair shake from FBI agent Peter Strzok. I should note, and the DOJ certainly did note, that neither of the agents who conducted the interview of General Flynn showed him the transcripts of the phone call with Russian Ambassador Kislyak, which was the subject of the interview. You know what else was odd about the interview? It was conducted without giving any heads up to the Department of Justice. Acting Attorney General Yates, who was no fan of President Trump to say the least, was, quote, flabbergasted, close quote, and, quote, dumbfounded, close quote, that the FBI was conducting the interview, stating that, quote, an interview of Flynn should have been coordinated with DOJ, close quote. You know who also recognized that failing to coordinate with DOJ was unusual and probably something he shouldn't have authorized? FBI Director James Comey, the guy who actually authorized the interview. In a December 2018 interview with NBC News analyst Nicole Wallace, he described that interview as, quote, something I probably wouldn't have done or gotten away with in a more organized administration, close quote. In the end, the FBI got away with conducting an interview that wasn't necessary because the investigation on which it was purportedly based was effectively, if not formally, over, and it had found nothing wrong done by General Flynn with the Russian government, which was the purported subject of the investigation. Moreover, there was no need to interview Flynn because the FBI already had a transcript of the conversation he had with the Russian ambassador. There was nothing for them to find out. Instead, they were simply trying to catch him in a lie. And the incoming national security advisor for a new president's administration meeting with the ambassador of Russia is normal. There's nothing nefarious on its face. And notwithstanding the interviewing agent's original conclusion that Flynn was in their appraisal not lying or didn't think he was lying, he was prosecuted for perjury, for purportedly lying about discussing sanctions with the ambassador. In one instance saying that he didn't think he discussed the particular matter with him, and in another instance saying that he didn't remember discussing the matter with him. That's it. So how did the government get General Flynn to plead guilty? Well, they played hardball. Flynn was being buried with legal expenses. He took out a mortgage on his townhouse in D.C. and then sold that townhouse to help pay for his legal expenses. He purportedly now still owes at least $4.5 million in legal fees. And then he was pushed with threats that the government would prosecute his son, who had recently become a father, for a purported failure to register as a foreign agent. The DOJ prosecutors entered into a secret side deal with the law firm that formerly represented Flynn that was not disclosed to the court as required, that Flynn's son would not be prosecuted if Flynn pled guilty. So what happened? Flynn cracked. Under financial pressure and the threat of prosecution of his son, he agreed to a deal that it seems clear now he never should have taken. But more importantly, the prosecution never should have occurred, and the DOJ has finally admitted it. Even former FBI Director James Comey admitted that he didn't know whether General Flynn lied, and it was a close call. So the assumption among much of the public that Flynn clearly lied is unfounded. But more importantly, as the DOJ set forth in its motion to dismiss the charges, it takes more than a showing that someone lied to support a charge of perjury. It's not enough for the statement to be false. It must be materially false. So it has to not only be relevant to the matter being investigated, but also have, quote, probative weight, close quote, so that it's, quote, reasonably likely to influence the tribunal in making a determination required to be made, close quote. The DOJ motion to dismiss the charges contains that quote from the case United States v. Weinstock out of the D.C. Circuit. So given that the investigation of Flynn for purported involvement in collusion with Russia didn't uncover anything and it was slated to be shut down, and only through bureaucratic inefficiency hadn't been, there was no investigation to support the interview and thus no case or tribunal to consider and be influenced by the purportedly false statements. And the government already knew the contents of Flynn's conversation with the ambassador, so there was no reason to interview Flynn to begin with. The bottom line? Even though Flynn's statements are far from clearly false, it doesn't matter whether they were, because they couldn't constitute perjury. So the DOJ dropped the charges. Long overdue. Next topic. Terrifying elite. Some of you have probably heard conservative commentators warning about politicians and bureaucrats and others on the left planning to or actually espousing using the COVID-19 crisis as a means to expand the powers of government, restrict the rights of the individual, and advance all sorts of public policy agendas which otherwise wouldn't stand a chance of being adopted. In the words of Rahm Emanuel, late of the Obama administration and former mayor of Chicago, never let a crisis go to waste. Well, I just read perhaps the most terrifying exposition regarding the historical document which provides the foundation for our government, which elected officials swear allegiance to and which I hold dear. What I just read didn't come from a politician, a bureaucrat, political commentator, or journalist. Who it comes from makes it potentially that much more frightening. It comes from a Harvard law professor, and Harvard is by far the law school which has produced the most Supreme Court justices, including a majority of the current Supreme Court. That the article I'm about to describe and the philosophies expressed in it came from a law school professor at arguably the most prestigious law school in the country and inarguably the most prominent in graduating Supreme Court justices is part of what makes it so terrifying. Unless something radically changes in the way that lawyers progress in the profession to federal judgeships and then to the Supreme Court, we can expect that Harvard Law School will continue to produce a disproportionate number of justices. So what exactly did this law school professor say that I found to be so troubling that I described it as terrifying? On March 31, TheAtlantic.com, a left-leaning news and commentary site, released an article by Harvard law professor Adrian Vermeulen entitled Beyond Originalism. The article is subtitled, "The Dominant Conservative Philosophy for Interpreting the Constitution Has Served Its Purpose, and Scholars Ought to Develop a More Moral Framework." The author begins by describing originalism, the judicial philosophy which says that the Constitution should be interpreted based on the original intent of those who drafted it as, quote, the faith, close quote. I find the choice of words to be strange, given that originalism actually attempts to determine what was meant by the people who drafted the document when they drafted the document. That determination is made based on evidence. By its very nature, it is the opposite of faith. But I suspect that the terminology was chosen more to be derisive than to be accurate. So what exactly does the author have in mind when he references a, quote, moral framework, close quote, and why exactly is that so frightening? We'll get a load of this statement from the august professor. He asserts that, quote, libertarian assumptions central to free speech law and free speech ideology, that government is forbidden to judge the quality and moral worth of public speech, that, quote, one man's vulgarity is another's lyric, close quote, and so on, close quote, must, quote, fall under the axe, close quote. Keep in mind that this man is almost certainly teaching future Supreme Court justices. Think about those words if you ever start to think that people like me are overreacting when we are screaming to the rooftops about infringement of our free speech rights and our fears for the future in that regard. If you're like me, you grew up hearing the phrase, the government can't legislate morality. Well, this law professor says that actually the government should be in the business of doing just that, and the Constitution should be interpreted as mandating that. The question I would ask is, whose morality? Well, this will give you some idea of what the professor has in mind. He says that, quote, common good constitutionalism will favor a powerful presidency ruling over a powerful bureaucracy, the latter acting through principles of administrative law's inner morality with a view to promoting solidarity and subsidiarity. The bureaucracy will be seen not as an enemy, but as the strong hand of legitimate rule, close quote. And he goes further, quote, constitutional law will define in broad terms the authority of the state to protect the public wealth and well-being, protecting the weak from pandemics and scourges of many kinds, biological, social, and economic, even when doing so requires overriding the selfish claims of individuals to private, quote, rights, close quote. Got that? Notwithstanding the fact that the Constitution was written by founders deeply skeptical of government power and provided for a means to amend the Constitution if the Americans of the future became dissatisfied with it, and notwithstanding the fact that the Constitution expressly recognizes that rights not granted to the federal government are reserved to the states or to the people, that reference to the people being to the very individuals and their rights to which this Harvard law professor ascribes selfishness on their part when they assert them. Now think about the ambiguities in what he's proposing. Basically, he's saying that the Constitution should be interpreted so that it promotes the common good, and that the common good must be sought by a powerful president and a strong bureaucracy which will be seen as the strong hand of legitimate rule. Can you think of any places where ambiguous references to the common good have been used to justify brutal authoritarian regimes? Can you think of any brutal authoritarian regimes that haven't said they were acting for the common good? I can't. Venezuelan strongman Hugo Chavez accomplished part of his dramatic expansion of dictatorial powers by amending their constitution. Here, a Harvard law professor is proposing reinterpreting our Constitution in such a way that I would argue it invites an authoritarian regime. And notwithstanding the claims in the article that the reinterpretation is being proposed out of a desire to promote the common good, I would argue it's something quite different. I would argue it's motivated by frustration that the population hasn't bought into what this Harvard law professor, and I suspect many of his brethren, view as the common good. This isn't the first time, and it won't be the last time, that a representative of one of our most elite institutions advanced a proposal that should make anyone who values their rights wonder what exactly makes that institution elite. Next topic. What if people move out of cities? There's been a lot of discussion about how people's lives will change and how the country will change because of COVID-19, even after the lockdowns are lifted. A friend of mine who's a real estate investor has been blunt and firm in his conclusion that any condominium that requires use of an elevator will be much less desirable in the real estate market for quite some time. If that ends up being the case, you can expect a severe impact on major cities. If that ends up being the case, will the attraction of beachfront access and views be enough to save Florida's waterfront condo developments? I don't know. But let's talk about the broader issue that doesn't just involve buildings with elevators. Will people move out of the cities? For years, those involved in urban development, primarily activists on the left, have preached that Americans want to move to the urban core. They want to live in redeveloped urban centers rather than the suburbs. And while there's certainly evidence of some very extensive and very expensive inner-city redevelopment, gentrification, it has never kept up with the desire to move to the suburbs. You just don't hear about the continuing desire to move to the suburbs because it doesn't fit the narrative. But now, are we potentially facing a massive increase in the desire to move to the suburbs and the more distant exurbs? One obvious reason for wanting to live in an urban environment is the availability of jobs. What if telecommuting explodes? What if you can choose to live anywhere because all you need is a telephone and a computer? I remember when I graduated, I had 3 job offers in 3 different states. One of those offers involved less money on its face, but it was in Louisville, Kentucky, which had an incredibly low cost of living. And if you really wanted to save money or have a big plot of land, you could move across the river into southern Indiana and work in Louisville. If telecommuting becomes as widespread as some people predict, Americans might have the ability to live anywhere, regardless of where their job is located. And it's not enough to ask what that would mean for the American employees themselves. What would it mean for their employers? The commonly stated reason for companies to headquarter in large urban areas is for access to a highly qualified labor force. If the bulk of their headquarters employees are actually telecommuting, then the size of the headquarters would be minuscule, and where it would be located would be irrelevant, so long as the company actually concludes that telecommuting provides a sufficient quality of work. That means if a large urban area really does offer a more extensive selection of highly qualified employees, those highly qualified employees would be free to pursue a telecommuting job at a corporate headquarters, even if the corporate headquarters were located in a small town in Nebraska. If that happened, large urban areas could be hammered by flight by corporations and by residents. And where would people choose to live? In the Sun Belt? Perhaps. That certainly wouldn't be a new development. But what would be new is the availability of the less expensive areas in those sunny states. In Florida, small cities or towns like Ocala in northern Florida horse country might explode. But what would happen politically? What would happen if huge numbers of residents of large urban areas, disproportionately Democrat, moved out into the country in other states, disproportionately Republican? Would the states swing into the Democrat column? It's possible, but I think long-term the tendency would be for voter views to eventually adjust to the norms for the environment. In other words, the parent who moves from New York City to Ocala, Florida, or Soddy Daisy, Tennessee, or Claremore, Oklahoma, might remain a Democrat, but the odds of their offspring becoming Republican would increase dramatically. And all I can say is that the Republican Party better be planning for just such a development. On a much shorter term, you know what I'll be planning for? Releasing the next episode of Political Spirits in 1 week, as always. Be sure to tell your friends about Political Spirits and like the podcast on Facebook at Political Spirits. And follow me and the podcast on Twitter at Franklin Rye. And remember, all episodes are now on YouTube as well, and the YouTube channel is named Political Spirits Network. If you're watching on YouTube, be sure to like and subscribe and hit the notification bell. And select all after you hit the bell. This is Franklin Rye. Thank you for listening.